Hey you guys, welcome back to the channel. If you haven't subscribed, please subscribe so that you can be notified when I go live or upload a new video, and please like this video. Okay, the first thing that if you guys haven't already checked out the other video that I made on CPS, I suggest you guys go back and watch that one. But the first thing that I want to say to every parent out there that's facing this issue is, first, start by knowing what your fourth, fifth, and 14th constitutional, what the amendments are. Those are your rights. That's your right to remain silent. That's your right to not have your home searched. That's your right to be a parent. That's your parental rights. So please, I suggest that you first start out by reading and memorizing your 4th, 5th, and 14th Amendment rights. Now, when CPS comes knocking at your door, the first thing that you want to do is you don't want to open the door. But if by accident you open the door to find CPS, first things first, be calm, be polite, and do not show any anger, nor do you defend yourself. They're going to start out by telling you why they are there. We received a call that your child is being abused. Okay, just for an example. Do not admit to that and do not deny it. Do not defend yourself. Just remain silent. That's if I can give you any kind of advice right there, just be silent and quiet. But at the same time, be polite, be calm. Don't show any anger at all. Remain perfectly calm and strong. They are at your door because someone called in a complaint against you. 9 times out of 10, these caseworkers only know what they were told and almost always have no real evidence against you. If you're one of the rare ones that's guilty and they have piles of evidence, not much I can do. There's not much that can be done, but you still have rights. So listen on. If you're someone that CPS has just knocked on your door, they likely have nothing on you other than what the caller claims. Allegations. That's it. And it's your word against theirs at this point. Just know this, okay? And I want you guys to take notes here, because it's important to take notes. The first thing I want you guys to take notes on is writing down your 4th, 5th, and 14th Amendment rights. Okay. This is important too. CPS begins their investigation and begins collecting evidence the moment you open your mouth and your doors to allow them in. Because until you open that door, CPS didn't know anything about you. Until you decided to open that door, they could start collecting evidence the minute you open your mouth. Because that's when, and they'll take whatever you say and they will use it against you. It don't matter if it's something nice. It doesn't matter if it's, you could be completely calm and they will still lie on you and say that you're an angry, aggressive person. So just know this, CPS begins their investigation and begins collecting evidence from the moment you open your mouth and your doors. So if you accidentally open the doors, first thing, say this: this is not a good time, and I would like to have an attorney present when we speak. And hey, if you can't never afford an attorney, just every time they contact you, I'm sorry, I don't have an attorney. I can't really even afford an attorney, but I am not going to speak with you until I have one. And you don't even have to explain that. The best thing to do is to remain silent. Plead the fifth. They come around, well, why haven't you gotten back with us? You tell them, I wish to remain silent. I wish to exercise my Fifth Amendment right. So after you tell them, I would like to have an attorney present when we speak, in most cases, the CPS worker will still try to get you to answer questions, and they'll still try to get you to let them in. And sometimes they'll be very forceful about this. Sometimes they will tell you, okay, well, if you don't let me in, or if you don't let me talk to your children, or if you don't answer my questions, I'll come back with the police, or I will remove your children. They are not allowed to tell you this. They're not allowed to make threats. And so when they do that, you are still to remain silent and remain calm. Don't be scared by any of their threats. Don't be scared by anything they say. You still decline and say, I wish to exercise my Fourth, Fifth, or whichever amendment that you're exercising at that moment, whether it be the Fifth Amendment to remain silent. I wish to remain silent. And they'll try to ask you, okay, well, what's your name? What's your children's name? I wish to exercise my Fifth Amendment right. Calmly. Every time they ask you a question, that's what you say. But they will still try to get in your home. Believe that. So, after telling them you wish to have even though that you're telling them you still wish to have the attorney present, they will still try it. They will still try it, believe me. But, do not become angry or say anything, because they will use what you say and they will twist it and lie on you later on. At this point, if she won't leave, tell the worker you're going to record the conversation. And, at this point, you're allowed to record them, but you really need to let them know that you are recording them. And a lot of times they'll say no. They'll say, no, you can't record me. And if they say you cannot record me, well, then you don't have to record them. Don't record them, But at the same time, explain to them, I'm sorry, I'm not going to continue this interview unless I can record this conversation in order to protect myself. So, again, you must advise the worker that you're going to record the conversation. If they decline, tell them that you can't speak to them unless it's being recorded, like I said, to protect yourself. Do not allow them in your home. Don't even leave enough space for them to look inside your home. If you have to, if you see that she keeps trying to look around you in order to spot inside your house, just step outside and close the door and speak to her outside the house on the porch. but do not allow them in your home, and do not allow them to even have a peek inside your home. So while standing just outside your door and recording, or you may not be recording at this point, this is your time to ask questions. Do not, under any circumstances, answer any questions. Do not admit to or deny any allegations. Only plead the fifth. But you do want to start asking them questions, because they are there because they got a call. And so you want to find out as much information as you can. And if you can't, if the caseworker will not allow you to record her at this point, then you have a right to have a pen and paper and take down notes. So these are questions that you want to ask the caseworker. Okay? These are questions that you are going to ask her. Don't give her time to be asking you all kinds of questions. And if she does try to slip in questions here and there, where are the children? Why can't I come in your home? Ma'am, I respectfully plead the fifth. And then get in questions as you can and calmly ask these questions. And you want to ask one question at a time. And you want to have a pen and paper on you. And even if it's a state that allows you to record, you still want to record, because even without their consent, as long as you let them know, in a lot of states, if you let them know that you're recording the conversation, there's really not much they can do about it. But you need to check the laws in your state to make sure that you're doing that. Now, if they start to enter your home illegally and unlawfully, that's a different story. You're going to be recording anyway. So here's the questions you want to ask. And, this is another thing you're going to take notes on. You're going to, number one, ask, can I see your ID? Then write down everything on the ID. First, last name, employee number, anything that's on that ID. And a lot of times they won't allow you to see an ID. A lot of times they won't even tell you their first or last name, because they know what they're about to do is illegal. Number two, what is the name and phone number of your supervisor? And write that down if they give it to you. And if they don't give it to you, hopefully you're recording this stuff. Hopefully you're recording all this, because you want all of this, and don't try to force her to give you this information, because later on in court, it's going to show, okay, well, she wouldn't even give her, she's here at her door, but she wouldn't even give her ID to prove who she was. There's all kinds of things that you can do, but how you react to things is going to be shown in court too, if it gets that far. So it's important to always remain silent and remain calm. One of the biggest things that they'll say in court is the reason why they're keeping the kids, or the reason why they removed the kids, was because of your anger. And you didn't cooperate, which was the furthest thing from the truth. They come in and steal your kids, but you're not supposed to be upset about that or cry. They'll look at somebody and see that they're crying because you're taking their children away from them. But then they go into court later on and they'll say that they were angry and they were very they were trying to get physical, which was a lie. So it's always important to record everything. Even if you're remaining silent, which is what you should do, you need to be recording everything. And number three, what are the exact allegations that have been made against me? And number four, do you have a warrant to search my home or to speak to my children? So the federal law gives you the right to know the exact nature of the allegations against you. They may try to say something vague, such as child abuse or something simple. They'll say, oh, it was, you didn't have food in the house, or child abuse, or child neglect, but no. You need to politely demand specific answers to that question. Like, okay, well, you say child abuse. I need you to be a little bit more specific. What do you mean? But very politely, not rude like I'm trying to sound now. And I'm not trying to sound rude, but this is a very sensitive topic, and I've seen a lot of things that's happened to people, and I know what happens. So they're very deceiving. Okay, so CPS usually don't have any information or even enough evidence to get a court order. Like I was saying earlier, usually when they come to your door the first time, they're coming to investigate. Because if they already had all the evidence they needed, they wouldn't be at your door. They wouldn't be at your door trying to ask you questions. They probably would already have a court order to remove the kids. So if they're just coming to knock on your door to ask you questions, they're not going to get any answers because you're not going to allow them to open an investigation on you. Because you're not going to give them any information to investigate. They only know what they were told and what the allegations are, but they don't have proof. It's your word against theirs. They can't come into your home without a court order unless they witness imminent danger. And see, this is where it gets tricky. Imminent danger is where your child's life is in danger at that moment. And many times they will lie to a judge to get that court order. Because they know that if you're young, 9 times out of 10, you can't afford an attorney. You have no way of defending yourself. A judge ain't going to just listen to you because you're not going in that courtroom equipped with the law on your side, because you don't know how to begin to look into these laws or your rights in order to protect yourself. If you go into court, okay, say that they did lie on you to get a court order, because a court order should be something that's really hard to get for something like this, because they need to have the proof. They need to have a great amount of proof that child is in imminent danger. And so they go in front of a judge and they say, okay, judge, we received this call, and this child, we suspect it, but there's no proof. But yet they've had to go and tell a whole lot more in order to get that court order. And either they have real proof against you because you've done something, or 9 times you're that 1%, or you're the other 9 out of 10 that is actually innocent, and they just wanted to get your kid. And so when that happens, that's also an unlawful removal. That means that you know, later on, you can sue them. You can sue them, and if you can prove that your child was not in imminent danger and that they fabricated that to a judge, you have grounds to sue. But keep that on the bookshelf until the case gets closed and everything's said and done, and then that's when you go out and you seek your lawsuit. So at this point, this has been going on far too long. This conversation with this caseworker should have been done and said, and should have already been back at her office, because at this point, you've already told her that you're not going to speak with her without an attorney present. So she shouldn't even still be there. So if you've already, a lot of the times, what you really want to do is, after you tell the caseworker that, you want to walk back in your door and politely close the door. Don't slam it. Close it nicely. And then, but before she does leave, you want to ask her those 4 questions, though. You want to ask her, as soon as she comes to the door, you want to ask her, may I see your ID? Can you explain the allegations in depth for me? Go back to the 4 questions. Get as much information as you can, and then tell her, this is not a good time for me. I would want my attorney present when I do speak with you, and say, if I get a hold of an attorney, I can have him contact you and maybe set up an appointment or something. Other than go back in and shut your door. Don't even sit there and let her keep on and on and on. That's the best thing to do. But like I said, and I keep saying this because this is so this, if I can't tell you anything else, this is the most important thing. Do not ever speak to the caseworker. She will ask you questions. Tell the worker very politely that you're exercising your 4th and 5th Amendment rights, that she cannot enter your home, and you wish to remain silent. Say this every time she asks a question. Even if you have to say it 100,000 times. I wish to exercise my 4th and 5th Amendment right. Very calmly. Okay, so if she tries to force her way into your home, or she makes threats to remove your child if you don't speak to her, like I said, that's illegal, and you need to record it. Stand strong and stand firm, but polite and calmly say, you do not have, if she's trying to force her way in there, or say that she went and got the police, and she comes back with the police, because sometimes they will do that. If you have to go to the door, and even then, you don't even have to go to the door. You don't have to answer the door. But if you go and answer the door, step outside on the porch and close your door. And calmly ask them, do you have a warrant? And if the police says, no, but your child is in imminent danger, so we're going to enter your home and we're going to take your children. Or we're going to enter your home and look around. Well, they're not supposed to do that. That's illegal. But they will try to say that your child was in imminent danger to try to get around that. And so what you do is you say, okay, give me just a moment. Walk in your house, shut the door. Go get your children, bring them to the door. Let the officer look at your children and let him stand outside and peek inside your home from the outside. Don't let them in. Say, you are welcome to, here are my children. Stand outside and look inside my home. My home is safe. My children are safe. There's nothing here that causes for them to be in imminent danger, at risk of death. Take your children back inside and close the door and talk to them outside and say, firm, politely and calmly, because they may still try to illegally, unlawfully enter your home anyway. You say, you do not have permission to enter my home. This violates my constitutional rights as a mother, as my home. You're invading my home. But if you continue to forcefully try to enter my home, you are doing so without my consent, and you are being recorded. At that moment, if they continue to try to get in your home, you are to record it, everything. Step aside so that you don't get hurt and they don't try to arrest you or slam you against the door or anything, because they will. Just step aside and say, you're doing this without my consent. And say this say it when it's being recorded, that you are doing this without my consent. So they went ahead and entered illegally. They just violated your rights. Continue to quietly record the worker and or the police in your home. And later on, after this, make sure that you record your kids too. Show that because if the allegations are that the kids are being abused, they have bruises all over them, make sure that you record it, that they don't have bruises. So that on the first court date, you're showing this to the judge. So, like I said, it's important to record everything. So later on after this, if, after everything is done and said, you're going to have grounds to also sue them. And as soon as CPS leaves, or you close your doors, contact an attorney as quickly as possible. Now, if you can't afford an attorney, like a lot of us, we just can't afford thousands of dollars, go to legal aid right away. They can help. If, what happens if CPS are at your door with a court order in hand to remove your children? In order to get the court order, CPS needs to show proof that an emergency removal is necessary. So, if they're at your door, they receive some kind of allegations, and they obviously are saying that they were able to prove that your child was in imminent danger to a judge. And so that is very hard to do. How do you prove that a child is in imminent danger without first being at the house to see what's going on? Because that is the only two ways that they can remove your children. They have to witness your child being in imminent danger, which means their life is at risk at that moment. Or they've went to a judge to get the court order, and then they come to your house to serve it. Many times this court order is gotten illegally. So you need to have an attorney with you with the first day of court. And usually what this first day of court is, it's like a 72-hour within 72 hours, in most states, they have to have a hearing to show that there was no evidence, but like I was saying, you need to have an attorney with you the first day of that court hearing to show that there was no evidence, that the children were in no imminent danger. And if you can prove that, then your children have to be given back to you. And okay, say that you can't, afford an attorney, or you can't get one from legal aid in time. But usually if they know that you only have 72 hours, sometimes they'll hurry up and rush you through so that they can take your case. But if that's not possible and you still can't find an attorney to at least take payments, then you're going to have to go in there. And you're going to have to equip yourself with the law. And I'm not sure if you have to motion the court to have the children released back into your custody at that hearing in order to be heard that day. But a lot of times CPS gets by with doing this stuff because you don't know the legal way in order to protect yourself. And whatever state that you're in, you need to find out what you need to do in order to get your kids back. And even if you can't afford an attorney in your state can tell you exactly, they can give you a free 30-minute consultation, and don't be ashamed to take that. Let them know, hey, they came to my house, they took my kids, my children were not in imminent danger, and I can prove that. Okay, well then that attorney is going to tell you what forms to file, because you'll already have a case number. You just file the petition, if that's what you need to do in order to be heard that day, at the first court hearing. Show your recording to the judge that day. Show whatever proof that you have, and let your voice be heard, and let the judge know, Your Honor, my children were unlawfully removed, and then give him the reasons why. And then tell him I am requesting that the court immediately release my children back into my custody. Hopefully that will work. And usually if you have an attorney and you do have proof, 9 times out of 10, they're going to release your child back to you. But if you don't go with an attorney that day and you're not equipped and you don't take that 72 hours and get to know what the laws are and know what your rights are, they're going to get you. And so I suggest you take, all that time to really, because you don't want this to drag out. You want to get those kids back at that 72-hour hearing, no matter what. If you're innocent and you have proof that they took your children unlawfully, you need to get your children back at that very first hearing. Now, what happens if, say that CPS comes to your house with or without a warrant, but they end up taking your kids for whatever reason, whether it be unlawful or whether they did it the right way. Because sometimes, and it's very rare, but sometimes they do things the right way. But on those times when they don't do it the right way, or even if they did do it the right way, the fact is that they took your child. Your child is gone. They're in CPS custody. the state's custody, and what happens immediately after they take your child? Well, 9 times out of 10, they want to hurry up and do an interview with you. So as soon as they take the kids, there will be a caseworker that you're going to talk to. And whatever you do, decline that interview. Do not sit through an interview and answer questions after your children are removed. Because a lot of times they will try to scare you into speaking to them, because they think, okay, after we take their kids, they're going to try to cooperate now. They're going to try to cooperate and do what we tell them to do if they want to get their kids back. And so I'm telling you, it is in your best interest. If you want your kids back at that 72-hour hearing, and you know you're innocent, you better not speak to them right after your kids are removed. They will try to have you sign a paper that is agreeing to take classes. If you sign that paper, that is the same thing as admitting, yeah, I need to take classes because I have anger issues, or I have, I need to learn how to be a better parent. So yeah, these parent classes will help me. Or I need to go through 6 months of drug rehabilitation, or, never sign anything for them. Never sit through an interview with them after your child is removed, because doing that is admitting guilt. You're admitting that you have a drug issue. You're admitting that you need to take parent classes, and that they were in the right to take your child. And then this will drag out and out and out. And I'm going to tell you something else too. At that first hearing, if they do not give you your child back, at that first hearing, you tell the judge and whoever else, I demand a trial by jury. You tell them that you want to have because you don't want this to drag out. Because at this point, you're already at the court hearing. So that means, and you're fighting to get your kids back. So that means that you didn't sign the papers they wanted you to sign. And you didn't have the interview with them where they got you to start talking. And if you start talking, you could say things like, yeah, I do stick my kid in the corner, and then they'll say, well, how long do you stick him in the corner for? And they'll play along like, oh yeah, I've had to do that too. Oh, how long do you stick them in the corner for? And you say, well, I stick them in the corner for like a minute for how old they are. They will use that and twist it, and they'll lie. They will lie on that first court hearing, because that's where they're collecting all their evidence in that interview right there. That's where they get you. And then they have you sign the papers. Do not sign those papers. And if they'll start saying, oh, well, what kind of a mom, won't sign these papers? Because, what's involved in these papers is for their medical treatment. No. Because then they'll have the right to stick your kid on any drugs they want to. Or get hospital records or whatever they want. Do not sign any papers. Period. I don't care what it is. And don't open your mouth. I can't stress that enough. So you're at your first hearing. You didn't sign papers, and you didn't agree to the interview. Now, if they refuse to hand your children back over, they at this point are unlawfully keeping your children hostage. So what you do is you tell them that you want a trial by jury, a jury trial. Because trust me, if you're innocent, you can get a whole bunch of witnesses also to come in on your behalf. Even if you have to represent yourself, you still want a jury, the people that are in society with you. You don't want a judge or CPS having the fate of you or your kids in their hands. And this is where a lot of parents go wrong, and they don't know what their rights are, and that you have to know that you do have a right to a trial. But if you don't, if they'll try to trick you into, signing these papers at court, and you're going to be so confused because they're going to say all kinds of, words. Don't sign anything until you tell the judge, I want a trial by jury. And even there'll be an attorney there that'll try to talk you out of it. No, I want my fate in the hands of 12 people. I don't want my fate in the hands of CPS and this judge, because they will drag it out. In 6 months after you're done, okay, if you foolishly signed any papers to agree to any classes, or to undergo any kind of treatment for these people, at the end of that 6 months, they're still going to put you through the ringer. Okay? It's hard to get your kids back once you sign all this stuff over. It's very hard. So, again, I hope that you demand a trial by jury, and that has to be done right away. It has to be done at that first hearing. Okay, and this is just everything. On some of the stuff, I don't know everything, but this is stuff that I have looked into. This is stuff that I've seen other people go through. And you have to know, and you have to learn what your rights are. And you have to know, especially if you're defending yourself, how to present this evidence, and how to put in motions, how to, you need to learn how to do this stuff in order to protect yourself and to protect your kids. Because it's not going to be easy. Like I said, whatever you do, don't even ask. Demand a trial by jury. A lot of people think that if their children are removed, that they have no hope. And it's because you're up against the government here. But see, and also, I'm going to tell you something else too. As soon as your kids are taken and this stuff starts, you want to get a copy of everything. Get a copy of every single thing before the trial starts. Before the trial starts, tell them that you want a copy of everything. All the court documents, everything. And if you get a court-appointed attorney, you want that attorney, 9 times out of 10, that attorney, he or she will go ahead and give you a copy of the allegations, the court forms, and everything. And what you want to do is and there could be 100 pages, there could be 500 pages. But it'd be a big stack of papers. And you're going to sit there and think, my God, what are they accusing me of here? Go through it all. Start with the very first page. And this is going to take you a whole day. Okay? First, make you make you a copy of it and then go through on the copy form of it. Keep a record for yourself. But then you are allowed to take that paper, that packet, and if there's anything on there that CPS alleges that's not true, you can cross it out and you can put the facts on top of it, and you can demand or request that your attorney has it corrected before it goes to trial. There's just a whole lot into it that you need to learn. And there's just, when it comes to your kids, you got to be like a lioness. You got to be fierce. And you have to be tough, and you have to be strong for your kids, because once they get in this system, you got to get them out of there as quick as possible. And it's not going to be easy. And with a government as your adversary, you're going to have to be tough. You can't just sit there and accept what they say, because they could tell you anything and you'll be like, oh, okay. But if you go in there and you know what your rights are, you can say no, and you can make demands and say, no, I know what my rights are. My right is to have a trial by jury, and I demand a trial by jury, because they will try to talk you out of that. They don't want that. So that's my advice. Don't sign no papers. Don't talk to them. And if your kids end up being taken, ask for a trial by jury. Now, there's one more thing that I want to go over with you guys, okay? What happens when you get you can't afford an attorney and they give you a state-appointed attorney? This attorney is not going to be working for you because they're on the side of CPS. You have to make them work for you. And you need to let that be known right away. And even your attorney will try to tell you, oh no, don't do this, don't do that. And you'll be sitting there with your attorney in court, and they will be lying on you. And your attorney would know better and have the proof otherwise, and will just sit there and not speak. And you're going to be sitting there like telling your attorney, you better say something. And they're still sitting there like a bump on a log. So you got to know how to make your attorney work for you. And there are letters that you can give to your attorney that explains what you expect out of them. And if they don't do what you tell them to do, you better learn real quick how to defend yourself in a trial jury or a jury trial. Because you need to. Because nobody can defend you better than yourself. You would hope that your state-appointed attorney would do that for you. But if they don't, you're going to have to step up. You're going to have to turn attorney, basically. So I'm going to read off here a sample letter that or I can put it up on the screen, on what you can say, what a letter that you can write to your court-appointed attorney. And you can, don't copy this verbatim. You can use some of the words, but try to twist it up to make it your own, make it into something that's your own. But this is like a sample. You can go off of this and kind of build into it. But you need to make sure that you serve this and make a copy for yourself. Keep copies of everything. And like I said, all the court forms and the allegations against you, make sure you get a copy of that so that you can go through it. And then to make sure that you take it to your attorney when you're done with it and tell the attorney, these are things that I don't agree with. And I want you to petition the court to have this changed. So, okay. Because sometimes they'll even get dates and times and they'll get people's names wrong. You need to go through, because these allegations against you, you want to read the whole thing and you want to correct anything that's not right. Or any lies. So let me go ahead and I will post this attorney thing, letters to the attorney that you can write to your attorney to make sure that your attorney is working for you and not those people that are paying him or her. You have been appointed to represent me as an attorney in the county juvenile court. Please be on my side. I need your help. I am fighting for the release of my 3 children, or how many other, this is just a sample letter. Make it your own. From state custody. I am innocent of any wrongdoing. The caseworker made assumptions about me that are false. My children need to be at home with me for their well-being. Mentally, I can't read that word. And physically. Okay. You guys, if you guys mentally, that's what it says. But if you guys need to enlarge this if you guys are going to be trying to go off of this. Hopefully nobody's going through this. While you are my attorney, please remember that you are working for me, not for the county that pays you. As my attorney, I ask that you give me the best legal representation available. I therefore request frequent face-to-face meetings with you so I can be sure you are actually working on my case and not letting it slide between the cracks. I understand that many court-appointed attorneys tend to simply guide parents through the juvenile court system, advising them to plead guilty to charges to make things easier for everyone else in the courtroom. This is not the kind of representation I'm requesting. I'm asking you to be actively involved in proving my innocence. I have not received any offers of... It's hard to read this. I have not received any offers of... I don't know, you guys have to read that because I can't read that part. Oh, I know what that's saying. It's saying that you need to, that she did not receive any offers to place her children with other family members. And 9 times out of 10, you're not going to get that. You're not going to get that because, and by law, federal law, they're supposed to try to place your child with family member, if at all possible. And they don't do that. Then it goes on to say, I'm hereby asking that you take my case to trial. And see, this is where it gets tricky because your attorney is not going to like that. and make the caseworker prove all charges since they are false charges. I believe it would be in my best interest and the best interest of my children if I were to fight to prove my innocence with a full trial. Do not ask me to plead guilty to false charges against me. See, this is where it gets tricky because your attorney is going to be mad. She's not going to want to. I don't know why I keep saying she. She or he is not going to agree to that. They're going to tell you and try to talk you into pleading guilty and signing the papers and doing what they tell you to do for months and months and months and months and months and years. Don't do it. Take it to trial before a jury, a trial by jury. And you demand it. And don't settle for less. And listen to what your attorney's saying in court. Because if you don't agree, you stop your attorney. And you say, no, I don't agree with that. I want a trial, I want a trial by jury or whatever. They may even come up and try to offer you, okay, we'll give your kids back if you just do this class, and you go ahead and plead guilty. And you say, no, I'm not going to be, I want a trial. I'm not pleading guilty. I'm not going to trust you to give my child back in 3 months if I plead guilty and take this stupid class. No, I want my child back immediately. I want to file or take this to trial. As you know, parents involved in CPS cases have to complete a service plan, yet many do so are still do not get their children returned. I would like to avoid doing these services as much as possible and request that you ask the caseworker to prove the need for any services requested. I do not want to be in the position of many parents in these cases forced to have psychology evaluations. Well, this small print is hard to read when there is no evidence of mental or forced to do drug testing when there is no evidence of drug abuse. Please honor my request, protect my best interest, and see that my time is not wasted by unnecessary court-ordered services. Of course, they would also be a waste of taxpayer money if I do not really need them. Do everything you can to question these services. I'm trusting you to fight these issues individually and fiercely. I understand that I am responsible for completing all court-ordered services and ask only that non-necessary services be an issue. I ask that you be 100% aware of what is happening with my case at all times and that you will inform me immediately of changes. Again, guys, this is extremely important. I ask that you obtain and share with me a complete copy of the case file, including all case narratives, because you want to go through it and make any corrections that you don't agree with, and then hand it over to your attorney. And in most cases, your attorney is going to be lazy. They don't want to do what you tell them to do. They think they know it all. You give it to them. You tell them, I want you to file this and file these corrections so that they can be legally made to where they're corrected. Because, I ask that you help me compile substantial evidence to prove my innocence in this case by preponderance of the evidence. I ask that you will produce legal paperwork, including a complete response to all caseworker reports, declaring supporting my side of the case, and other documents as needed, and that you will present those documents to the judge or juvenile court referee who hears our case. I ask that you do everything you can to prevent my name from being included on the central index, which blacklists people from working with children. I am innocent and my name should not be included on that list. Please resort to my request. Please respond to my request in writing within 10 days. I will need your written response for my records in this case. Sincerely, whatever your name is. So, first thing you want to do as soon as you are given a court-appointed attorney, okay, the first hearing, your child was not given back to you. You're going to be given a court-appointed attorney, or you make sure you request one. The first thing you want to do, the minute you leave the court, call the office and make an appointment with that attorney, because they're not going to make an appointment with you. And what you want to do, because a lot of these court-appointed attorneys, they want to meet you inside the courtroom, and they're reading your case as if this is the first time they've ever seen your case. You don't want that. You want to meet with your attorney. You want to hand her this letter or mail it to her, but I would hand it to her. But make sure you have a copy of it for yourself. I can't say this enough, and I'm going to repeat it again before I end this video. First things first, keep your mouth shut. Even your attorney will tell you that. Once you open your mouth, you've given up all your rights. If you speak to them, your rights go out the window. Do not speak to them. Do not sign their papers that they want you to sign. Do not plead guilty. Ask for a trial by jury. So I hope you guys take my advice. I'm not an attorney. I don't claim to know all the laws in all the states. I don't know. I'm just telling you, as parents, this is what you got to do. These people are going to come at you dirty as a snake. You've got to learn how even you can be the best-hearted person, humble, quiet, a good person, thinking, okay, I'm innocent, so I have nothing to hide, so I can talk to them. No. Your little humble butt better get as fierce as they are, because they're going to come at you with everything they have, and you have to come at them with everything you have. So that's all I got for you. You got to be just as fierce as they are. You got to know what your rights are. Don't plead guilty. Don't sign papers. Don't speak to them. Don't say a word. The only thing you say to them is, I wish to exercise my 4th and 5th Amendment rights. That's it. What's your name? I wish to exercise my 4th and 5th Amendment right at this time. And you say it with a smile. Say it politely. Say it nice, While you're recording, just show that your voice was not in an angry tone, as they will say in court against you if they take your child. Hopefully they just close the case and they walk away and they leave knowing that they don't have evidence. Hopefully it don't get to that point. But if it does, know your rights. And then after everything is said and done, look back at your case and see, did they violate my rights? Did they violate any of my constitutional rights? Because if they did, you have a right to sue them. Even if it's in small claims court, even if you take it to a higher court, you can even represent yourself in that, where if you can't find an attorney, because a lot of these attorneys don't want to fight the government. But you can do it yourself. Just know what your rights are. Know what the laws are. If it's your child, you thought you were a parent, now you're an attorney. So that's all I have for you guys. I hope you guys have a wonderful day. I wish you luck. And because if you're watching this video, it's because you're probably in this situation. And I pray for you. You're in for a ride. But if maybe you're somebody that just came here because you want to know what to do the next time they come knocking at your door, just know what your rights are as an American citizen. Don't easily give up your constitutional rights, because once you do, they're gone. There's people that fought for that, for you to have those rights. Take advantage of them. They're yours.